Namaskar, Lordship. Namaskar, Lordship. Namaskar.
Namaskar. Namaskar.
Namaskar, Lordship. May I request all the participants to be on mute mode, please? Madam Amrupali, can you please
Namaskar,
mute
Lordship.
yourself
Namaskar.
and switch off your
Namaskar.
camera? Madam Amrupali Telgod. Namaskar, Lordship. Hello. Good morning. Good morning, Jay. Lordship, with your kind permission, can we start now?
Yes, please.
Thank you. Thank you, Lordship.
Yes.
Dr. Gitanjali, please start now.
All right. Respected all, a very warm good morning to you from Guwahati.
Good
Where
morning.
the universe is in small places close to home, so close and so small that they cannot be seen on any maps of the world. Yet they are the world of the individual person. Unlike his rights has meaning there, they have little meaning anywhere. These are the words of Eleanor Roosevelt, who was one of the members of the drafting committee on the International Law that went on to be adopted as the UDSR. Human Rights Day is observed every year on December 10th, the day when the Universal Declaration of Human Rights was adopted, way back in 1948. The 75th anniversary of which to be celebrated next year. The theme for this year is dignity, freedom, and justice for all. In line with the International Observance of Human Rights Day, this special lecture on human rights has been organized by the Center for Human Rights and Humanitarian Laws in collaboration with the IQAC and Pro Bono Club, National Law University, and Judicial Academy Assam. May I now call upon our Honorable Vice Chancellor, Professor Dr. B.K. Ahuja, to kindly deliver the welcome address. sir.
Thank you, Dr. Geetanjali. Honorable Mr. Justice UU Lalit, former Chief Justice of India and Distinguished Professor of Law at National Law University and Judicial Academy, Assam. Honorable Mr. Justice Kalyan Rai Surana, Judge, Guwahati High Court. Dr. Indranushi Das, Registrar, National Law University, Assam. My respected colleagues from the university and my colleagues from outside the university from different parts of the country. Dear admin officials and dear students, participants, a very good morning. Martin Luther once said, injustice anywhere is a threat to justice everywhere. Whatever affects one directly affects all indirectly. The same can be experienced from Ukraine war, which has been imposed by Russia and which is to be called as unjust war. Whatever is happening today in the Ukraine is affecting the entire world. There is shortage of food, there is shortage of fuels in many countries. Many students, and the students who were foreigners and studying in the Ukraine will have to discontinue their studies. The violations of human rights and humanitarian laws in Ukraine are impacting the human rights of the people of other countries of the world. We need to regain universality of human rights. In order to promote and recognize the 75th anniversary of the UDHR, the Office of the United Nations High Commissioner of Human Rights has launched a year-long campaign with the theme, as Gitanjali had rightly put, dignity, freedom, and justice for all. It is an honor to have Honorable Mr. Justice UU Lalit, former Chief Justice of India, with us today on the occasion of International Human Rights Day. National Law University and Judicial Academy Assam is honored and privileged to have Honorable Lordship as Distinguished Professor of Law. On behalf of entire NLUJA family, I express our sincere gratitude to Lordship for accepting our invitation of being a part of the NLUJA family. We wanted to host Lordship at our campus so that Lordship could address the students in the offline mode. Since the end semester examinations are starting from day after tomorrow, so I thought it proper to invite the Honorable Lordship in the coming semester to the NLUJA campus so that Lordship could interact with students and also motivate them for their professional journey. With these words, I welcome Honorable Lordship to this virtual event and look forward to hear his words of wisdom. I also welcome Honorable Mr. Justice Kalyan Rai Surana, Judge, Guwahati High Court. Lordship has always been very kind to us. His able and timely guidance helps university to deal with adverse situation. Lordship has also been coming and taking classes of our students. We are thankful, Lordship, and we welcome you to this particular program. I also welcome all professors, students, and participants who have joined this morning from different parts of the country. Thank you very much. Namaskar.
Thank you so much, sir, for delivering the welcome address. May I now call upon Dr. Kasturi Gokul to kindly take forward the program of the day.
Good morning to one and all. Thank you, Gitanjali. I'm Dr. Kasturi Gokul, and it is my great honor and pleasure to introduce our speaker for the special lecture on human rights, Honorable Justice Uday Umesh Lalit, former Chief Justice of India and Distinguished Professor, National University and Judicial Academy, Assam. Welcome, Your Lordship. Lordship had enrolled as an advocate in June 1983 and specialized in criminal law and practiced at the Bombay High Court from 1983 to 1985. Lordship was designated as a senior advocate at the Supreme Court in April 2004 and aided the court as an amicus curiae in many important matters pertaining to forest, vehicular pollution, and pollution of the Yamuna River. In 2011, Lordship was appointed as a special public prosecutor in the 2G Spectrum case And he also served as a member of the Supreme Court's Legal Service Committee for 2 terms. The Supreme Court Lordship was elevated as the judge of the Supreme Court directly from the bar on 13th August 2014, and as the judge of the Supreme Court, he was appointed as the executive chairman of the National Legal Service Authority on May 14, 2021. Lordship took over as the 49th Chief Justice of India on August 27th and 2022 and served as the Chief Justice of India till November 7, 2022. Lordship had focused on achieving the maximum efficiency through limited resources, and it was during the tenure of Lordship that the live streaming of the Supreme Court hearing was put to practice. We are very much honored to have you amongst us, Lordship. And Lordship had also introduced, rather be a part of many notable judgments, including the introduction of 3 procedural safeguards to prevent the misuse of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. Lordship was also part of the 5-judge constitution bench, which heard the Triple Talaq case in 2017. And also recently in November 2021, Lordship led the 3-judge bench with regard to the interpretation of Section 7 of the Protection of Children from Sexual Offences Act. We are very much honored to have you, sir. Thank you for your presence. And now I kindly request your Lordship to deliver the special lecture on human rights, sir.
Good morning to one and all. Justice Surana, Judge Guwahati High Court, learned Vice Chancellor, all the professors, members of the teaching staff, all the students who are connected through video conferencing today, all ladies and gentlemen. It's a great pleasure to be part of this discussion on a day which is marked as Human Rights Day. As the earlier speaker stated about the statement of Eleanor Roosevelt, who was chairing the drafting committee when UDHR, that is Universal Declaration for Human Rights, was drafted and adopted. That marks the beginning and that marks the entire tone of this discussion. As the learned Vice Chancellor said, dignity, freedom, and justice for all is now the motto after 75 years, and that also sets the tone for what lies in store and what can be expected on this front of human rights, maintenance and preservation of. Well, friends, Human Rights Day is observed every year on 10th of December, the day the United Nations General Assembly adopted in 1948 the Universal Declaration of Human Rights, which are normally known as UDHR. The UDHR is a milestone document which proclaims the inalienable rights that everyone is entitled to as a human being, regardless of race, color, religion, sex, language, political or other opinion, national or social origin, property, birth, or other status. When we think of history of the declaration, the Universal Declaration of Human Rights was adopted by the UN General Assembly on 10th of December 1948, which was the result of the experience of the Second World War. With the end of that war and the creation of the United Nations, the international community vowed to never again allow atrocities like those of that conflict to happen again. World leaders decided to complement the UN Charter with a roadmap to guarantee the rights of every individual everywhere. The document they considered, and which would later become the UDHR, was taken up at the first session of the General Assembly in 1946. The Assembly reviewed this draft declaration on fundamental human rights and freedoms and transmitted it to the Economic and Social Council for reference to the Commission on Human Rights for consideration in its preparation of an International Bill of Rights. The Commission, at its first session early in 1947, authorized its members to formulate what it termed as a preliminary draft International Bill of Human Rights. Later, the work was taken over by a formal drafting committee consisting of members of the Commission from 8 states, selected with due regard for geographical distribution. The Commission on Human Rights was made up of 18 members from various political, cultural, and religious backgrounds. Eleanor Roosevelt, widow of American President Franklin D. Roosevelt, chaired the UDHR drafting committee. The entire text of the UDHR was composed in less than 2 years, at a time when the world was divided into Eastern and Western blocs. Finding a common ground on what should make the essence of the document proved to be a colossal task. If we consider the text of the rights which are spoken of under UDHR, and around the same time when our Constitution of India was also drafted, you will have parallels like, for instance, Article 7 of UDHR, equality and equal protection before law, is what we have in Article 14 of the Constitution. Similarly, remedies for violation of fundamental rights, which is the subject matter of Article 8 under UDHR, is what we have, the corresponding under Article 32 of the Constitution. Protection in respect of conviction of offences, Article 11.2 of the UDHR, is what is translated in Article 20 in sub-article 1 of the Constitution. Thus, we have number of these articles, and the guarantees which are given by UDHR are identically sort of worded in Constitution of India, or at least the intent and the spirit behind that is something which gets completely translated. For instance, right to freedom of conscience and to practice, profess, and propagate any religion, freedom of speech, equality in opportunity of public service, protection of minorities, right to education, which of course is a recent phenomenon through Article 21A by the amendment to the Constitution. In order to preserve these rights and to check the violation of such rights, or to give remedy or succor to in case of such violation, European Court of Human Rights is one of the premier organizations. The Convention for the Protection of Human Rights and Fundamental Freedoms, better known as European Convention on Human Rights, was opened for signature in Rome on 4th of November 1950 and came into force on 3rd of September 1953. It was the first instrument to give effect to certain rights stated in the Universal Declaration of Human Rights and make them binding. Under the original system, 3 institutions were responsible for enforcing the obligations undertaken by the contracting states: the European Commission of Human Rights, the European Court of Human Rights, and the Committee of Ministers of the Council of Europe. All applications lodged under the convention by individual applicants and contracting states were the subject of a preliminary examination by the Commission, which decided whether they were admissible. If a complaint was declared admissible and where no friendly settlement was reached, the Commission drew up a report establishing the facts and expressing a non-binding opinion on the merits of the case. The Commission and or the government of the state in question could then decide to refer the case to the court for a final binding adjudication. If the case was not brought before the court, the Committee of Ministers would decide. Let us not get into the mechanics and how the developments thereafter took place. But suffice it to say, the last decision of the Grand Chamber of European Court of Human Rights handed down a landmark judgment announced on July 11, 2022, just few months earlier, against Turkey for its failure to carry out the court's order to free the imprisoned human rights defender Osman Kavala. Human Rights Watch and the Turkey Litigation Support Project said today. The court found in Kavala versus Turkey, a case brought by the Council of Europe's Committee of Ministers, that Turkey failed to fulfill its obligations under Article 46 into bracket 1 of the European Convention on Human Rights to comply with its judgment issued on December 10, 2019. The judgment is an important step forward and towards the accountability of Turkey's systematic disregard for the convention system and as recognition of the urgency of implementing the court's order to release Kavala. These are, of course, the international ideas. Now, back home, coming to the Indian scenario, we have through various judgments. Now, there's no point in going into every single judgment, but just broadly, some of the features of the cases decided by Supreme Court, the highlights or the milestones in that behalf are, take for instance, Francis Corale Mulin or Sunil Batra or MS Hoskote or finally DK Basu, which were cases decided by the Supreme Court, taken up by the Supreme Court in order to maintain the sanctity, the purity, the dignity of these rights. The dignity of a human individual, of a human being, is something which was the center of all these decisions and the cornerstone of this entire jurisprudence. In many cases, Indian Supreme Court has referred to, relied upon these universal declarations of human rights. For instance, in Jolly George Verghese, Article 12 of the Universal Declaration of Human Rights was referred to, relied upon, and it was stated by the Supreme Court, quote, everyone as a member of society has the right to social security and is entitled to realization through national effort and international cooperation and in accordance with the organization and resources of each state of the economic, social, and cultural rights indispensable for his dignity and the free development of his personality. In a very unique case which dealt with inhuman conditions in which 1382 prisons in the country were found to be functioning, in a judgment rendered in 2016, Justice Lokur also traced everything and to the concept which is Universal Declaration for Human Rights. Some of his observations in paragraph 10 of that decision, if I may just quote. With regard to the entitlement of a prisoner on death row to have meetings and interviews with his lawyers or members of his immediate family or even mental health professionals, we are of the opinion that such meetings and interviews should be permitted. We follow the view expressed by this court in Francis Corale Mulin in paragraph 8 of the report. It was specifically noted by this court, after referring to the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, that is a part of the right to live with human dignity, a prisoner is entitled to have interviews with members of his family and friends, and no prison regulation and procedure to the contrary can be upheld as being constitutionally valid under Articles 14 and 21 of the Constitution unless it is reasonable, fair, and just. Similarly, there cannot be any doubt that a prisoner must be entitled to have discussions with his lawyers so that he has effective legal representation and access to justice as well as remedies for justice. In our opinion, the law laid down by this court in Francis Corale Mulin would be equally applicable to death row prisoners for meeting mental health professionals for a reasonable period of time and with reasonable frequency so that their rights can be adequately protected at all stages. Another case which was decided very recently, sometime in September 2022, that is Vinod Katara. In that case, paragraph 3 of the judgment says, fundamental principles to be followed in administration of these rules are, number one, the state government, the Juvenile Justice Board, the Child Welfare Committee, or other competent authorities, as the case may be, while the following principles shall, inter alia, be fundamental to the application, interpretation, and implementation of the Act and the rules. What is that? Principle of dignity and worth. Treatment that is consistent with the child's sense of dignity and worth is a fundamental principle of juvenile justice. The principle reflects the fundamental human right enshrined in Article 1 of the Universal Declaration that all human beings are born free and equal in dignity and rights. Respect of dignity includes not being humiliated, personal identity boundaries and space being respected, not being labeled and stigmatized, being offered information and choices, and not being blamed for their acts. And secondly, the juvenile's or child's right to dignity and worth has to be respected and protected throughout the entire process of dealing with the child, from the first contact with law enforcement agencies to the implementation of all. Now, these were just some of the cases which I just quoted. The underlying idea is that every person, every human being is entitled to what is normally called dignity, freedom, and sense of justice, and treatment which is equal to everyone. That's the fulcrum of every jurisprudence which touches upon or deals with human rights. Now, let us test the development and go and take cases one by one. Now, for instance, let us see Sunil Batra. What was Sunil Batra? Sunil Batra was a case where a death row convict, immediately after the first judgment rendered by the trial court, was segregated and kept in solitary confinement. The judgments which are rendered by Justice D.A. Desai and Justice Krishna Iyer, both the judgments, the lead judgment is by Justice D.A. Desai. They deal with what? They deal with one basic idea, that as a human being, he should not be put in such condition or environment where the basic idea that he must have human contact with fellow citizens or fellow prisoners, or even the minimum kind of human dignity and touch should be denied or deprived to such person. So therefore, the law which was laid down was that till the death sentence is finally pronounced upon by the highest court of the land, the man should not be denied the benefit or the freedom of having company with fellow prisoners. That was Sunil Batra. We took a step further. In one of the judgments by the Supreme Court in Ajay Kumar Pal, that supposing if a person has actually been segregated like this while he was handed down a death sentence, will it be a relevant circumstance to say that his death sentence be commuted to life imprisonment? Ajay Kumar Pal went on a point, on 2 points. Number one, such segregation which is not authorized by law and which was against the principles laid down in Sunil Batra was taken as one factor or one ground. And the second ground was delay in considering the representation or delay in considering the mercy petition which was lodged by the death row convict. On these two grounds, Ajay Kumar Pal, which is a bench of 3 judges of Supreme Court, commuted the death sentence to life imprisonment. That's the kind of relief which was granted to the person concerned who was wrongly kept in solitary confinement, which was direct violation of human dignity. But of course, it was put on 2 counts. In a recent judgment, which is B.A. Umesh, again a bench of 3 judges of the Supreme Court, put it purely and solely on the violation of law laid down by the Supreme Court in Sunil Batra. And what is that law? The law is that Sunil Batra says that you must treat every individual with dignity, which is commensurate with freedom and justice, concepts of freedom and justice. And justice demands that till his death sentence is finally pronounced upon, he is entitled to all the rights which every human being, a living human being, is entitled to. On that solitary ground or sole ground that he was kept in solitary confinement against the principles of Sunil Batra, the death sentence was commuted to life imprisonment. And that's the role which Indian courts or the Supreme Court and all the superior courts in the country are performing. Any violation of human dignity is something which has to be met with succor being granted to the person concerned. So, this was one line of cases which I placed before you. A second line of cases, D.K. Basu and all the directions which have been issued by the Supreme Court from time to time. Now, D.K. Basu says that every prisoner, every under trial is entitled to certain protections, certain rights which are commensurate with human dignity. Any violation of that, what shall be the result? The result is now the judgments of the Supreme Court or the orders passed by the Supreme Court say that any such violation which has been at the hands of those persons who have arrested the man will entail in action in contempt. So the police officers who are responsible for violating the directions issued in DK Basu would naturally be visited with penalty in contempt jurisdiction. So that's the level to which the Indian courts or the jurisprudence has gone. These are two basic ideas or instances. Now the third, custodial violation. Custodial violation or violation of fundamental rights of a person who is in custody is also one of the features that we have to deal with when it comes to our Indian courts. For instance, Rudul Saha. Now, in a writ petition, whenever there was violation which was alleged or attributed to police, or any custodial violence was alleged to have been inculcated by the police, the Supreme Court said that even in Article 32, we can grant compensation, and the compensation must initially be paid by the state entity, which would then be recovered from the erring or the guilty officials. So these are some of the ideas which the Indian courts have always evolved as tools or as mechanics to see that the human rights are not violated. And in any case, if there be any violation, then that violation is also met with iron hand, and the solace or succor is afforded and granted to the person in question. The victim is sufficiently taken care of. Now, last and not the least, we today have victim compensation schemes. These are also the modalities or the evolutions as a result of judge-made law. Many of the cases where girls have been subjected to offenses under 376 or have been subjected to acid attacks have, as a result of persuasion by the courts, now part of various victim compensation schemes and are provided again solace by now executive form schemes. But the intent behind that, or the galvanizing force behind that, was the persuasion by the courts. So all in all, what we have is that so far as the statutes are concerned, the Declaration of Rights are concerned, our Constitution sufficiently takes care of that. These sublime and these basic rights are guaranteed under our Constitution. The right to seek remedy is also guaranteed in the form of Article 32 at Part 3 level and at the constitutional level under Article 226. The courts have been always vigilant to afford any relief or solace to the persons concerned, to the victims. And as I told you, the extent of grant of relief by the courts have gone to such extent as evidenced by the progression from Sunil Batra to Ajay Pal to now the last case, which is B.A. Umesh. So therefore, even a person who is on a death row has to be treated with great sense of dignity. And that sense of dignity is something which is the all-pervading idea in our constitutional jurisprudence. And that is something which we all are proud of. So with this note, I end my discussion on this point and flag the same three thoughts or three pointers, which is dignity, freedom, and justice to all, is the hallmark of or is the basic idea behind every human rights jurisprudence. Thank you, all of you. Thank you.
Thank you, Your Lordship, for your enlightening lecture and valuable insights into the numerous judicial pronouncement in India, the development of jurisprudence of courts in India, and the evolution of mechanisms and tools for upholding the protection of human rights in India, and also giving a reflection on the development of the human rights in the regional human rights system. Thank you, Lordship, once again. I now call upon Dr. Diptimoni Borua, Madam, to please deliver the vote of thanks.
Thank you, sir. Welcome. Good afternoon to one all. Sorry, good morning to one all present here. Today is the biggest day in the history of the humankind. International community adopted the Universal Declaration of Human Rights 75 years back. This declaration sends a strong message to the global village that all human beings are born free and equal in dignity and rights, and no authority in any country can deny the basic human rights, irrespective of their religious and political affiliation and economic development. Therefore, we all must stand for it. To mark this significant occasion memorable, the National Law University and Judicial Academy Assam organizes this special lecture with distinguished legal luminary of the country, Honorable Mr. Justice U. Lalit Sir, the former Chief Justice of India and distinguished professor of National Law University and Judicial Academy Assam. Lordship has discussed various striking human rights issues, as mentioned by Kasturi Gokul, with his excellent legal proficiency. I'm sure these words have enlightened the minds of the people present here. On behalf of the National Law University and Judicial Academy Assam, I'd like to extend my deepest appreciation and profound gratitude to Honorable Mr. Justice U. Lalit Sir for gracing this occasion and his thought-provoking ideas sharing with us. Lordship, we are deeply honored to have you with us, and I hope you will not deprive us from your knowledge and blessings in the near future. Thank you, Lordship.
Thank you.
I express my sincere gratitude to Honorable Mr. Justice K.R. Surana, Judge Guwahati High Court, for blessing us with his gracious presence. Thank you, sir. I wish to express my sincere thanks to Honorable Vice Chancellor of NLU Assam, Professor B.K. Ahuja sir, with his dynamic leadership, heavy cooperation, and constant support, and make this program possible. Thank you very much, sir. My big thanks to the Register of the NLU Assam for continuous support and help us. Thank you, madam. I extend my sincere gratitude to all the esteemed participants whose presence and blessings make this program successful. I also extend my thanks to the organizing team, especially Dr. Kailash Singer, Dr. Kasturi Gokul, Dr. Gitanjali Ghosh, Shetyaji Dev, and Himanshu Shonwal, and all teachers, students, and non-teaching staff of the National Law University for their cooperation. Once again, I thank you, Lordship, and all the participants to bless us with their blessed presence. Thank you very much and have a nice day.
Thank you, Lordship, for being with us today morning.
Thank you.
And we would like to see you at our campus in the next semester.
Oh, yes, yes. It would be my pleasure. I'm privileged to be there. So, thank you.
Thank you, Lordship.